I'm Nikki Jovicic from Lookupstrata. I'm also the Managing Director of Tower Body Corporate. I'm delighted to introduce Ben Seccombe, a partner from Mahoneys, who is joining us today to discuss a significant case that has implications for the management rights and strata industry in Queensland. As many of you know, there has been some uncertainty surrounding the validity of caretaking agreement extensions. Some practitioners had suggested that these agreements can only be extended once and never for a term exceeding the maximum allowed in aggregate. In a recent case, Mahoneys, supported by Arama and EBM Insurance, challenged the validity of extending caretaker agreements, seeking clarification on whether the agreements can be extended and for how long. This is a significant victory for the industry as it removes a potential barrier to the renewal and extension of caretaking agreements, and it also provides greater clarity and certainty for both management rights holders and bodies corporate. Ben will provide valuable insights into this case and its implications for the industry. Welcome, Ben. What is a top-up or extension on a caretaking agreement?
Well, caretaking agreements and the same principles apply to letting agreements as well. I suppose that's the one thing just to keep in mind when we talk about this particular case. It concerned two identical sections, one which applies to caretaking agreements, one which applies to letting agreements, but the principles and the outcomes are exactly the same, even though the sections are numbered differently. But in short, caretaking agreements are contracts, and under the legislation, they have a maximum term depending on which module applies to your particular community title scheme. If you're a standard module scheme, that is 10 years. And if you're an accommodation module, it is 25 years. And so what regularly happens is once the time has elapsed, whether it be 1 year or 2 years, fairly commonly 5 years, the caretaker or letting agent will request an extension of that term back up to the statutory maximum limit. And if they've been a good caretaker or a good letting agent, then often the lot owners will reward that performance by granting that extension, and that then extends the term of that agreement to last for another 5 or 2 years, depending on what's been requested and put up to the general meeting for approval.
And can you tell us more about the recent case? What was the recent decision regarding caretaking agreements in Queensland?
So where this came from, it was a body corporate down the coast, Atlantis West. There was a caretaker who'd been there for some time, had put up a motion to the general meeting to have the term extended, and that motion was approved by the lot owners. The applicant in this case, who is a lot owner in that scheme, then applied to the Body Corporate Commissioner for an order seeking to invalidate that extension on the basis of what he said was his interpretation of the relevant module, which in this case was the standard module.
What was the reason for the legal clarification?
The argument, in short, from the applicant was that the way the modules are to be interpreted is that instead of allowing bodies corporate to top up as they choose for a period of no more than 5 years and in any event for no longer than that statutory maximum period, you could only top up once and once only, and then never for more than the total length of the allowed term. And that was really the nub of the dispute. So to explain that in a different way, if you have, if a body corporate enters into a contract with or a caretaking agreement with a caretaker, and that term is 10 years, then in essence, what they were saying was, well, that's a standard module scheme. You've already had your 10-year term. You can have one top up of 5 years, but after that, never again, no matter what. And at that point, the agreements end, and effectively the body corporate is left without any caretaker, or the caretaker is left without any agreement whatsoever. The orthodox or commonly understood interpretation of the legislation and the modules is that if you've got a 10-year agreement, once that time winds down to, say, 7 years, the body corporate can, in general meeting, agree to top up or extend that agreement as much as it likes, or as many times as it likes, provided it doesn't then go above that 10-year period. So if it was 10 years and it's come down to 7, you can only top it up again by 3 years to 10. If it was down to 5, by 5 years to 10. And then the only twist on that is because the maximum extension in any year is 5 years, if you had a 10-year agreement and you were down to, say, only 3 years left, you could top it up in this year only by 5 years, so back up to 8 years. And then the caretaker has to wait another year, by which time it's down to 7, and then go 3 back up to 10 again. So where this comes from is, I think historically there'd been concerns about caretaking agreements or everlasting agreements, which just had automatic rolling top-ups. So the body corporate was effectively locked into these everlasting agreements, which weren't necessarily in their best interests and over which they had no say as to whether they were extended. So under this mechanism, you're only allowed to propose one extension every year. And as I said before, those extensions can't be for longer than 5 years. And for standard module schemes, no matter what, they can never go beyond 10 years. So that was really what it was about.
And why was the applicant's challenge unsuccessful in this case?
Largely, it was a question of the interpretation of the wording of the module. So it was a rather dry and probably boring to many people statutory interpretation argument. And in essence, the applicant was trying to read into the module words which we said just weren't there and didn't need to be inserted. And our position was you just read the module the way it has been written and in accordance with what Parliament had said it was meant to achieve. And that really, when you read adjudicator Miskinnis's decision in this, is really what he focused on. There's a particular section of the explanatory notes from Parliament when they passed or implemented this legislation. And sort of the last sentence of that, if you'll forgive me reading it, is just that it says the purpose of the limitation is to prevent the body corporate unreasonably locking itself into long-term agreements that may be to its disadvantage. This limitation does not prevent the body corporate from subsequently deciding to give another extension that complies with the same provisions. So it seemed to us, and obviously to the adjudicator as well, that it's pretty clear that what that means is that provided you comply with the procedural requirements of the module, and provided you're not topping up for more than 5 years, and provided that when you add that option, you're not going over the statutory maximum, then that's what the module allows.
What were the potential consequences if the applicant had of one?
This could have had some fairly diabolical consequences on both sides. I think the biggest issue obviously is, caretaking agreements have been around for a long time, and it's not uncommon for people to have agreements that in a standard module scheme might have been put in place in 2005 and are now 20 years down the track, which have been bought and sold, and they'd essentially be left with nothing. A lot of these caretakers are mum and dad operators. They're effectively small businesses, and they would have been left in a position where they had their entire livelihood just taken away at the stroke of a pen. The other, I suppose, related aspect of that is banks, when they're lending money to people to buy these management rights, they look at that as part of the value of what they're lending on. And if that value suddenly evaporates, these small business people could have been effectively bankrupted because they'd then be looking to the other assets of those people to recover what they're owed. There's however many more than 50,000 community title schemes in Queensland now. You multiply that issue across the state, it would have been an absolute field day for lawyers, but not good for the industry. I think the flip side of that is you then catapult any number of bodies corporate into a position where they've got this issue with their caretaker, trying to navigate that with their lawyers acting for the body corporate, saying, how do we deal with this? You've potentially got good relationships with caretakers who are now left in a position of having to renegotiate new agreements. It would have been a bit of a shockwave, I think, and it's good that it didn't get upheld.
Is it still advisable to seek legal counsel regarding caretaking agreement extensions?
Absolutely. It's certainly not compulsory. It won't necessarily invalidate a top-up that has been granted. And that's one of the complaints which the applicant made in this case, was that the body corporate hadn't either sought or disclosed legal advice about the top-up that had been requested to the lot owners. Bodies corporate don't need to do that, but I think as a matter of best practice, committees who are being asked to consider a top up and the deed of variation that usually comes with them, it's a good idea to get that legal advice just to make sure everything's being done properly and the body corporate understands and can explain to lot owners what they're voting for, as the case may be.
Okay, well, thank you very much, Ben, for spending the time with us today and explaining the case. It's very interesting to hear about that, and well done.
Pleasure. Thanks for your time, Nikki.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.